Hi, I'm Jonathan Kappy.
And I'm Fred Tonelli.
Welcome to Holland Estates. Today you're listening to episode number 628, and today we will be discussing affidavits. How you doing, Fred?
Good, Jonathan. How are you today?
I'm good. We've got an interesting one. The case itself is kind of mundane, but I like the issue that it raises. So why don't we jump right into it? And why don't you tell us a little bit more about the case?
Right. So the case is Teefy Developments and Son. This was a 2021 decision from the Ontario Court of Appeal. And the interesting thing here is the moving party in this case did not read English. I believe they spoke Chinese, either Mandarin or Cantonese. And they had an affidavit sworn by their lawyer. And the judge brought up the good point in the context of the decision that the deponent would not have been able to understand the affidavit that they swore to, and that this was a problem because this goes against the Commissioners for Affidavits Act. And so the issue here being that in such a circumstance, you're supposed to actually translate the affidavit to the person's language that they can understand, and then make a note of that at the jurat at the end of the affidavit in English. And essentially the judge is giving a public service announcement to lawyers to in the future avoid such situations, because it's not good enough to say, well, this is just how it's done in the industry, because we have professional standards, and obviously that would not be up to standard.
Right. So I think that while it really didn't have a lot to do with the decision, the court questioned how the client could have sworn the affidavit, and the lawyer I think should not have answered this way, but the lawyer answered that everyone knows that affidavits are prepared by lawyers and clients simply sign what the lawyer tells them to sign. Not a good answer to give to Justice Nordheimer. And so we are going to do a public service announcement for Justice Nordheimer in the Court of Appeal and talk a little bit about affidavits and commissioning affidavits. So a lot of people don't know this, but affidavits are governed by Rule 4.06 of the Rules of Civil Procedure. All right, and the Rules of Civil Procedure set out what affidavits are to look like, their form, that they have to state the deponent's name, et cetera, and they have to be signed by the deponent and commissioned. 4.06 sub 2 talks about the contents of an affidavit. The affidavit shall be confined to statements of fact within the personal knowledge of the deponent or other evidence that the deponent could give if testifying as a witness in court, except where these rules provide otherwise. And there are different rules for giving evidence on your information and belief, and it depends on the context in which the affidavit is being submitted. So a lot of people don't know that you can actually have more than one person swear the same affidavit. All right. And the rules provide that where there's an affidavit being sworn by two or more people, there has to be a separate jurat for each deponent, unless all the deponents make the affidavit before the same person at the same time, in which case the one jurat containing the words sworn or affirmed by the above named deponents can be used. So you can't have it, it's got to be, but we have to change the jurat. Similarly, an illiterate or blind person can swear an affidavit. And again, the jurat has to be a little different. Now, in the case that we're dealing with, we're talking about someone who does not understand English. All right. And clearly the affidavit was submitted to the court in English, and the person who swore it had no idea what they were signing. Okay. So in that particular case, the rules require that where it appears to a person taking an affidavit, so to the commissioner, that the deponent does not understand the language used in the affidavit, the person shall certify in the jurat that the affidavit was interpreted to the deponent in the person's presence by a named interpreter who took an oath to make an affirmation for him or her to interpret the affidavit correctly. So when I do this, what you do is you sit down with the affiant, you sit down with the interpreter. All right, and you make sure that the interpreter is someone I make sure that they're certified to do translations. And you go through the affidavit and you sit and you watch this entire affidavit from beginning to end, including exhibits, get interpreted for the deponent. And then what I do is I have the translator swear an affidavit that she is or he is certified that they have duly and properly translated the affidavit to the deponent. And I mark the affidavit as an exhibit to that translator's affidavit. And then I have the deponent actually swear the affidavit, which is in English, and you tweak the jurat to show that it was interpreted to them in your presence by the named interpreter, and that all together forms a package, which is the affidavit. And sometimes it looks weird because the affidavit of the interpreter comes before the affidavit of the actual deponent, but that is the proper way to put forth an affidavit when your client or the deponent does not speak English. So it doesn't really have much to do with the case itself, but we did want to put it out there and sort of remind people how things ought to be done when there is an opponent who doesn't speak English or illiterate, blind, or there are other circumstances. Rule 4 talks about different types of circumstances where the jurat has to change. And so I think now with the remote commissioning and changing the jurat, we're a little bit more comfortable with recognizing that the jurat is not set in stone and that you can play with it if the circumstances warrant. So, but I think that's really all we have to say and all we have time for. I want to thank you all for listening. I'm Jonathon Kappy.
And I'm Fred Tonelli.
Should you have any questions, please email us at info@hollandhall.com or contact us through the contact page on our webpage. Have a great day.